Hi and welcome back to my channel. So today we are going to do just a random Lpm revision. The exam is tomorrow, and as always, we the last minuters, the one who want to wait until a few minutes before the exam to read. Now our anxiety and excitement, adrenaline is on the high. So let's begin with discrimination. I'll be very fast with this revision, so I won't go into the details much. Okay, so chapter 10, the book I'm referring to is Mary Kimari, Management, Legal Practice Management. Now, the Black's Law Dictionary defines discrimination as the unfair treatment or denial of normal privileges to persons either because of their race, age, sex, religion, opinion, or nationality. And this distinction is not reasonable. So you are trying to favor others based on an unreasonable difference. There's this term called direct discrimination vis-a-vis indirect discrimination. Now, direct discrimination is the treatment of a person less favorably than others in similar circumstances. For example, where a teacher favors a student by virtue that they are a student when the rest of the class are also students. So we have one case, Republic versus Birmingham, where the judge stated that direct discrimination occurs where an individual is denied an opportunity or a choice that is available to another individual in similar circumstance. So where the teacher denies a student uh, an opportunity perhaps to participate in the sports competition and uh, and accords another student who is also a similar student from the same class in the same maybe in the same situation the opportunity to participate. So, in the House of Lords held in this case that denying girls admission to grammar schools but admitting boys is direct discrimination against girls. So this was irrespective of whether or not grammar schools are better than other schools. So the fact that this particular grammar school was not admitting girls, but it was admitting boys, was held to be direct discrimination. Now, unlike direct discrimination, let's look at indirect discrimination. This one is subtle, it's not overt, and can sometimes be unintentional. Indirect discrimination occurs when a particular criterion, practice, or norm disadvantages a particular class of persons unless it is objectively justified. So this is where discrimination is not apparent. It's not easy to see. It's indirect. It is subtle. It is maybe as a consequence of a particular action, and the indirect discrimination results. Okay, we'll look at more examples later. So, an objective justification allows employers to set requirements that are directly or indirectly discriminatory. For example, um, let me just say, for example, where uh, there's a point I remember somebody asked me back in college, why do you like Muslims uh, only eat halal meat? Why do you have to say Bismillah when you're slaughtering your cattle or your like for meat, you know? So I say that is a requirement of the religion. God, Allah requires us to say Bismillah over the animals while slaughtering it, because otherwise the meat is not edible. You can't eat the meat if that's those requirements required by the the religion of Islam is not, if they are not met, you can't eat the meat. So he was insinuating that just because Muslims in Kenya have been given that go ahead to slaughter cattle in that specific uh, um, scenario, like in that specific locality or in the country, it is indirectly discriminating the rest of the people or denominations which don't require that particular requirement. So it's not direct, but it is indirect. It is subtle, based on a justified objective. The objective is this denomination or demographic of people in this country will not be able to eat unless this kind of thing is done, this kind of process. Okay. um uh, so so there are requirements that you can justify your objective for indirect discrimination. uh, the goal is, or the requirement is, to have the reasons be, or the means be proportionate for achieving a legitimate end. So you do not exceed that specific that specific means. Okay, so by proportionate to mean that an employer must show that whatever he or she is doing must actually contribute to a legitimate aim. For example, if your aim is to facilitate the recruitment and retention of employees, then one ought to have evidence that the provision or criterion introduced is actually doing so. Okay, so the effect of the discrimination should significantly be outweighed by the importance and benefits of the legitimate aim, and one should have no reasonable alternative to the action they are taking. Where the legitimate aim can be achieved by less or non-discriminatory means, then this means must take precedence. So indirect discrimination is allowed as a last resort. You as an employee must, and as an employer must accommodate or must use other alternatives before you arrive or you decide to use this indirect discrimination as a last resort. And of course, whatever means you are using must be proportionate to the advantages, sorry, to the outcome. That outcome must be, the advantage or importance of that outcome must be weighed against the use of that discrimination to ascertain whether it is proportionate or the means that have been used are proportionate uh, or not. Okay. A legitimate aim might include economic factors such as business needs and efficiency. For example, the procurement process in public institutions can be indirectly discriminatory against the youth. The tendering process usually requires a supplier to have previously supplied public institutions with goods or services at least 3 times. This requirement excludes young entrepreneurs, particularly those who are setting up their business for the first time. So we are given an example of indirect discrimination where we have tender process. You apply to an organization uh, to have them choose you, but they prefer people who have experience or previous experience supplying goods to public institutions. So the person who is a newbie or someone who is starting out can feel discriminated against because of lack of experience. But this this is the objective is justified and the means are proportionate to the aim, which is a legitimate aim. They want goods that are perhaps sustainable, goods that are of quality, and goods that are, tested and true. You understand? So moving on, we have yes, the English Impairment Appeal Tribunal in Watches of Switzerland versus Saville held that recruitment and promotion processes that were systematically unfavorable to women, persons whose ethnic origin was outside the UK, and other classes of individuals were illegal for being indirectly discriminatory. So in this company, I think um they were trying to recruit, okay, and the processes that they were using to promote their products, which I think are watches, yeah, to promote their products and to recruit new employees was held to be the processes were held to be unfavorable to women and people who were not English, okay, whose ethnicity was not English, and other classes of individuals were illegal. So the court held that this recruitment process and the promotion process was illegal for being indirectly discriminatory. In David Wanjau Muhoro versus Olpejeta Ranching Limited, Justice Riga characterized indirect discrimination as discrimination that is unrecognized and uncombated. So this justice gave recognition to this indirect discrimination, that even if it's not apparent or obvious, it still exists. Okay. A legitimate aim must correspond with a real need of the employer, and the test of objective justification is not an easy one. So, the test of objective justification is not easy, and it must be backed up by evidence. Okay. Positive and negative discrimination. So, after we looked at direct and indirect, we have positive and negative. There are, however, positive and negative facets to discrimination in general. On the one hand, negative discrimination is unfavorable to a certain class of persons on various grounds. For instance, an advertisement for a job that reads "Librarians wanted, women need not apply" can be said to be negatively discriminating against women by actively excluding them. Positive discrimination, on the other hand, is the treatment of a class of individuals more favorably than others in similar circumstances for the purposes of redressing previous disadvantages. So, mm, yeah, so you are treating a class of people more favorably than others in the same circumstances. So I think this positive discrimination is the one we are familiar with, where a class of students in the same standard, in the same level, and a teacher favors a group of them and leaves out the rest, or treats the ones that are favorite to him better and gives them more uh, opportunities than the rest. Okay. It has also been referred to as affirmative action. So this positive discrimination is also known as affirmative action. This practice has been adopted in Kenya with regard to women under Article 27(8) of the Constitution, which sets out the two-thirds gender rule. The rule seeks to ensure that women actively participate in the governance process in Kenya due to the fact that they had been underrepresented. So, Article 27 generally is about discrimination based on gender, the male and female gender. Let me read it out, just a minute. So the Article 27 on equality and freedom from discrimination. Every person is equal before the law and has the right to equal protection and equal benefit of the law. Equality includes the full and equal enjoyment of all rights and of fundamental freedoms. Okay. All right. So women and men have the right to equal treatment, including the right to equal opportunities in political, economic, cultural, and social spheres. And sabbatical 4, the state shall not discriminate directly or indirectly against any person on any ground, including race, sex, pregnancy, marital status, health status, ethnic or social origin, color, age, disability, religion, conscience, belief, culture, dress, language, or birth. A person shall not discriminate directly or indirectly against another person on any of the grounds specified, which are the ones we say, like age, race, religion, conscience, belief, whatever. Um, so, all right. So that is Article 27. Um, Now, moving on. In Mary Wangui Gagunju versus City Council of Nairobi, Justice Nduma held that positive discrimination in favor of disabled persons is a universally recognized principle that is intended to facilitate affirmative action to that class of persons who are disadvantaged by their disability. So you can argue that positive discrimination is where discrimination is a good thing. Like in the case of the class of persons who are who are left out of jobs and education and stuff. So in this case, the judge held that, the positive discrimination in favor of disabled persons is accepted and recognized because it is affirmative action to promote these people or this group of people who have been disadvantaged before. Fairness at work and good job performance go hand in hand, thus tackling discrimination helps attract, motivate, and retain staff and enhance your reputation as an employer. Where there is unfairness, which I have also observed, where you notice that your employer is not giving you the same opportunities based on competence or performance, but rather based on favoritism, you will start refusing to cooperate or produce like you've produced before. You will limit yourself because you will know that even if you go an extra mile, even if you put in extra hours, it will not matter because the employer is not going to notice or is not going to reward you based on how much you are doing or you are producing, but rather whether they like you or not, or they've known you for a long time or not, or whether you are their friend. So that is what means when you're talking about fairness at work being directly proportional to the uh, to good job performance, which is true because of that example I've given. Once you start noticing unfairness at work, you get you lose your motivation to perform. You also feel resentful, and you will want to just do the bare minimum and go home, you know. It will not be the about you know your your passion in the work. It will not be the same. You will feel like you don't really need to do much, because whatever you do, your employer is not gonna notice or reward. Perhaps even whatever ideas you have, they are going to take credit for them or reward somebody else, okay, for your idea. So what happens is, it's actually um, it actually encourages uh, quitting of by employees who feel lack of motivation, who feel they've been discriminated against, who feel there's no fairness at the workplace. Okay. Now, the legal and policy framework on discrimination in Kenya. Now, Kenya has ratified other international treaties other than regional and international, other than the Constitution of Kenya, and by virtue of, I think, Article, I think 2 sub-article 6 of the Constitution says that any law in any country that's been ratified, any international instrument ratified by Kenya, is part of the laws of Kenya. So that's why we have all these other treaties and and conventions. So before we look at this, the one that comes to mind is about discrimination against women, CEDAW, the Convention on Elimination of Discrimination Against Women, and that talks about how women should be accorded the same opportunities to be hired and the same pay, equal pay for equal work, equal pay for equal work, and they should be given also the same opportunities that men are given, especially in male dominated occupations. Okay, so we have another convention. We have Universal Declaration of Human Rights in Article 1, which says all human beings are free and equal in dignity and right. As long as you are a human being, you are born free, you have no servitude to anybody, and you should not be made a slave to anybody. You are free and you have equal rights, okay, to enjoy your life, to possess, to live, and to work wherever you want, and to move, and all these things, okay. Article 2, on any grounds, okay. Article 23, sub-article 2 provides that everyone, without any discrimination, has the right to equal pay for equal work. So the one which I say is also part of the Universal Declaration of Human Rights. Remember, this declaration was made back in 1948. That's a long time ago, and ironically, this time the African countries were mostly colon colon colonized. They were colonies of the British Empire and other empires in the West and in Europe. So it's very ironic that when they made this Universal Declaration in 1948, they did not factor in the the what do you call it, the perhaps their definition of a human being was based on their perspective of who that human being was at the time, maybe a civilized human being or something, because this declaration could have not existed alongside the colonies. Okay, so that is that. Moving on, Article 26, International Covenant on Civil and Political Rights. This is Article 26, International Covenant on Civil and Political Rights. Okay, they haven't really clarified. Let me just see here. Yeah, this covenant came into force in 1976, and I think it's about the right to vote in to vie for political seats, the right to safety, uh, while campaigning, and all those things. And civil rights are rights that are owed to you just for being, for existing, So let's just have a look at it. So it was Article 26. So Article 26, let me just look. Yeah, Article 26 says all persons are equal before the law and are entitled without any discrimination to the equal protection of the law. In this respect, the law shall prohibit any discrimination and guarantee to all persons equal and effective protection, okay, against discrimination on any ground such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. Now, just a thought came into my mind, and I realized that the people who actually came together, or the countries which came with, uh, which founded these conventions, or kind of thought about them, most of them are Western countries, or countries which really must have come up with these laws just because of their past or their history of colonialism, and how they discriminated. I don't know about other places in the world, but Africa or Kenya, and they subjected it to slavery and servitude, and took all the lands and properties and everything for themselves. So in I mean, it was about time they came up with these laws. But for the rest of the countries like us here, the rest of the world which were colonized, we were already respective of each other's dignities and rights. Okay, we respected one another. We lived in communities, and our welfare was not individualistic or capitalistic. It was about the good of the whole community. Even ownership of land and stuff was not selfish oriented, but it was for the good of all of us. Okay, so that you would not find a homeless person, as long as that person had a name and they had a clan from which they originated. We were all for each other. So these laws, to be honest, they they are in existence because of these people's conscience or lack thereof at the time. And of course, all these articles that have gone into detail about discrimination based on race, or it's because they discriminated other human beings, or most of the human beings on this planet who didn't look like them or speak like them or believe like them. They already judged the rest of the world, which is different from them, as less than. Okay, that is why these laws have come into into existence, for them, for their conscience first and foremost, for the countries which have a history of slavery, of inflicting slavery on other countries, for their ratification, and also for their cleansing of all the, of all the guilt. Okay, you can't cleanse the guilt, but I'm just saying that these laws, they made them, and they required every country, including countries like Kenya and other former colonies, to ratify. And it was actually for them. These laws are for them to have them in their mind, and also to reflect on past actions which they have done, you know, based solely on discrimination. Okay, so I thought I should just throw that inside there. Anyway, so yeah, so all human beings are born free and are equal in dignity and rights, and this means all human beings, all of them, okay, regardless. Okay, so Article 26 was, we said, was the everyone has equal protection of the law and should not be discriminated on the basis of sex, gender, or you just conscience, belief, just that whole train of words, you just let it out. Article 7, Covenant on Economic, Social, and Cultural Rights. This was a covenant formed in 1966, and it came into force in 1976, so 10 years later. Okay, so we have Article Article 7. Article 7 of this covenant says that the state parties to the present covenant recognize the right of everyone to the enjoyment of just and favorable conditions of work, which ensure, in particular, number one, remuneration, which provides all workers as a minimum with fair wages and equal remuneration for equal work. So there is like these conventions. These conventions are all based off of the the Universal Declaration of Human Rights, which also, if we recall, had a section which says, had an article, sorry, Article 23, which advocates for equal pay for equal work. Now, when it comes to specification, all about employment and discrimination in the economic spheres, cultural, social, they specified it in this convention, okay, because that is where it falls. Employment, it falls under the economic sphere. Now, fair wages, equal pay, equal work without distinction of any kind, in particular, women being guaranteed conditions of work not inferior to those enjoyed by men, with equal pay for equal work. a decent living for themselves and their families in accordance, a decent living. So we have fair wages and a decent living for themselves and their families in accordance with the provisions of the covenant, uh, of the covenant convention or covenant. I don't know if it's the same thing. Safe and healthy working conditions, equal opportunity for everyone to be promoted in his employment to an appropriate higher, so equal promotion, fair wages, a decent living environment, and time to rest. Okay, that is Article 7, especially for women. Now, I was just watching snippets of the movie Les Miserables. So, where they were showing women who were so exhausted. They looked exhausted, downtrodden, even poor, and they're working in this workshop under very strenuous circumstances, supervised by this man who would like sexually uh, who would like just touch them in the wrong places because he called. So they were working tedious hours, long hours for measly tiny pay. So I mean this in the international arena, especially during industrialization and those other uh, time periods where things were really, where working was really for survival. If you don't, if you're not patient, if you're not tough for the work, you don't eat that day. So it's important that this kind of laws were set to help minimize, because a lot of lives would have been lost by then before the convention. And yeah, those conditions were so poor that they kind of shocked the world. We even had child labor, like children were as young as 7 or 8 had to also work in those workshops with suits all over, and it's crazy. So moving on, then we have CEDAW, the one I said, Convention on Elimination of All Forms of Discrimination Against Women, which was formed in 1979. Article 11 provides for freedom from discrimination of women in all social spheres, including employment. So CEDAW, yeah, CEDAW is this convention which Kenya also ratified, that requires countries to stop discriminating against women and girls in all areas, including employment, and requiring countries that have ratified to promote women and girls' rights, okay, to education, to employment, to everything, to voting, everything is there. So this was Article 11. Let's take a look at this. Excuse me. So Article 11 is about state parties shall take all appropriate measures to eliminate discrimination against women in the field of employment in order to ensure, on a basis of equality of men and women, the same rights, in particular, the right to work in as an inalienable right of all human beings. So women should have the right to work, the right to equal employment opportunities as men, the right to free choice of profession and employment, the right to equal pay, including benefits, the right to social security in cases of retirement and employment, the right to protection of health and to safe working conditions. Uh, so to introduce maternity leave with pay, uh, to encourage provision of the necessary supporting social services, to enable parents to combine family obligations with work responsibilities, to provide social protection to women during pregnancy in types of work given to them. Protective legislation relating to matters covered in this article shall be reviewed periodically. So it's all about elimination of discrimination in employment. So there you talk about the conditions of work, safe conditions, maternity leave, whatever. Yeah, just all of those things. Now, International Convention on Elimination of All Forms of Racial Discrimination. This was formed in 1965. Excuse me, let's look at it. International Convention on Racial Discrimination. Okay, so we have this International Convention on Elimination of All Forms of Racial Discrimination. Uh, article, which article? Article 5 prohibits discrimination, including in the context of employment relationship. So Article 5 is saying uh, uh, we have the right to equal treatment before tribunals and courts of law. We have the right to security of person, the right to political rights, to participate in elections, to vote, to vie, the other civil rights, the right to freedom of movement and residence, the right to live any country, the right to nationality, to marriage and choice of spouse, right to own property alone as well as in association with others, the right to inherit, the right to freedom of thought and belief and religion, the right to opinion and expression, the right to freedom of opinion and expression, the right to freedom of peaceful assembly and association, economic, social, and cultural rights, the right to work, to free choice of employment, to just and favorable conditions of work, to protection against unemployment, to equal pay for equal work, to just and favorable remuneration. So the right to free choice of employment, favorable conditions, favorable pay. Okay, so moving on. Convention on the Rights of Persons with Disabilities. This one, let's see, the last one. The Convention on the Rights of Persons with Disabilities, number Just a minute, it's taking longer to load. Yeah, so this is Article 27. Oh, it seems I downloaded a Chinese version. Just a minute. Okay, so it was Article what? 27. Okay. Article 27 on work and employment. State parties recognize the right of persons with disabilities to work on an equal basis with others. This includes the right to the opportunity to gain a living by work freely chosen or accepted in a labor market and work environment that is open, inclusive, accessible to persons with disabilities. State parties shall safeguard and promote the realization of the right to work, including for those who acquire a disability during the course of employment, by taking steps to ensure through legislation that they prohibit discrimination on the basis of disability with regards to all matters concerning employment, including conditions of recruitment, hiring, and employment, career advancement, and safe and healthy working conditions. Protect the rights of persons with disabilities on an equal basis with others to just and favorable conditions of work, including equal opportunities, equal remuneration for equal pay for equal work, safe and healthy conditions of work, protection from harassment, and the ability to complain or tender grievances. Ensure that persons with disabilities are able to exercise their trade union rights like others, to have effective access to general technical and vocational guidance programs, placement service, and vocational training, promote employment opportunities and career advancement for persons with disabilities, promote opportunities for self-employment, entrepreneurship, and cooperatives, employ persons to work in the public sector, promote employment of persons with disabilities in private sector, ensure that reasonable accommodation is provided in the workplace, promote acquisition by persons with disabilities of work experience, promote vocational and professional rehabilitation. They are not held in slavery, servitude, and are protected on equal basis with others. Okay, so that is the Convention on Elimination. Excuse me. Convention on the Rights of Persons with Disabilities. Okay, so we move. International Labour Organization treaties on discrimination. So International Labour Organization. Now we've moved from general conventions to more specific treaties regarding working conditions or work. Now Kenya has ratified or has adopted this International Labour Organization conventions. There's one on equal remuneration. Uh, Article 1 of the convention provides that the term equal remuneration for men and women workers for work of equal value refers to the rates of remuneration, so it applies to both men and women. The other convention under this labor organization is the Discrimination Convention of Employment and Occupation, which says the term discrimination includes any distinction, exclusion, or preference which has the effect of nullifying or impairing equality of opportunity or treatment in employment or occupation. Now, those are the two conventions under the labor organization. Now we have regional treaties. Further, Kenya has adopted several conventions under the auspices of the African Union. They include African Union Youth Charter, Protocol on the Rights of Women in Africa, Protocol on the Establishment of an African Court on Human and People's Rights, African Charter on Human and People's Rights, African Union Cultural Charter for Africa. We can just look at one of them. Okay, so let's look at this Protocol on the Rights of Women in Africa, that is. So it includes uh, provisions against FGM, child marriage, and roles in political processes. It's also called the Maputo Protocol, protecting African women's rights. Maputo Protocol. Now, harmful traditional practices like FGM, child marriage, roles in political process, economic empowerment. Let's look at economic empowerment. So let's just look at the Maputo Protocol. Article 1. For the purposes of the present protocol, okay, it's just definitions. Let's go to Article 2. Elimination of discrimination against women. State parties shall combat all forms of discrimination against women through appropriate legislative, institutional, and other measures In this regard, they shall include in their national constitutions and other legislative instruments, if not already done, the principle of equality between women and men, and ensure its effective application, shall enact and implement legislative or regulatory measures, including those prohibiting and curbing all forms of discrimination, particularly those harmful practices which endanger the health and well-being of women, integrate a gender perspective in their policy decisions, legislation, and plans, take corrective and positive action in those areas where discrimination exists, support the local, national, and regional continental initiatives directed at eradicating all forms of discrimination against women. They will commit themselves to modify social and cultural patterns of conduct of women and men through public education, information, and communication strategies with a view to achieving elimination of harmful cultural and traditional practices uh, based on the idea of the inferiority or the superiority of either of the sexes, or on stereotyped roles for women and men. So, article articles. Let me look at economic. Just a minute. Employment. Okay. So, Article 13 on economic and social welfare rights, state parties shall adopt and enforce legislative and other measures to guarantee women equal opportunities in work and career advancement and other economic opportunities. In this respect, they shall promote equality of access to employment, promotes the right to equal remuneration for jobs of equal value for women and men, to equal pay for equal work, ensure transparency in recruitment, guarantee women the freedom to choose their occupation, create conditions to promote activities of women, establish a system of protection for women working in the informal sector, introduce a minimum wage for work and prohibit the employment of children, take the necessary measures to recognize economic value of the work of women, guarantee adequate and paid pre- and postnatal maternity leave, ensure equal application of taxation laws to both men and women. Yeah, benefits, allowances. Okay, so that is the Maputo Protocol. Uh, Now, national laws. We have the Constitution of Kenya, and we said Article 27. Other than that, we have Article 20, which provides that equality and equity are values to be promoted in interpreting the Bill of Rights. Article 10, which is about principles of governance, provides that human dignity, equity, social justice, inclusiveness, equality, non-discrimination. So all these are principles of governance, including non-discrimination, protection of the marginalized, so and also the preamble to the Constitution, which lists equality as one of 6 essential values upon which governance should be based. Article 21 creates a duty on state actors to address the needs of vulnerable groups in society. Then Article 27 is for equality and freedom from discrimination based on gender and any other aspects or area. Every person is equal before the law and has the right to equal protection of the law. Equality includes full and equal enjoyment of all rights and fundamental freedoms. Women and men have the right to equal treatment, including the right to equal opportunities in political, economic, cultural, and social spheres. Um The state shall not discriminate, whether directly or indirectly, and we define both those terms against any person on any ground, including race, sex, pregnancy, marital status, health status, ethnic or social origin, color, age, disability, religion, conscience, belief, culture, dress, language, just all of those areas that apply to a human being uh, in the course of living, I would say. So a person shall not discriminate directly or indirectly against another on any grounds. So it's not only the state, but the person to person, state to person, people who enact laws, also legislative bodies, to the common mwananchi. Also, whatever laws they create must be checked, okay, so that they are not discriminatory. Any measure taken shall adequately provide for benefits, okay. In addition to the measures, the state shall take legislative and other measures to implement this non-discrimination principle. Okay, so mm, now Article 33 provides for freedom of expression, and also they are limited. So it's not an absolute freedom. And Article 55 provides for specific rights for young people, defines youth as those between the ages of 18 and 35. This article provides a range of specific rights for access to employment for youth. Now, Article 54 focuses on the rights of persons with disability. Article 22 and 23 regulates procedural aspects of instituting a claim under the Bill of Rights and provides that every person has the right to institute court proceedings claiming that their rights under the Bill of Rights have been denied, violated, infringed, or threatened. Now, Persons with Disabilities Act, Section 15, subsection 1 of the Act prohibits discrimination against all persons with disabilities at all stages of the employment process, that is, recruitment, selection, induction, and socialization of employees. The National Cohesion and Integration Act, the Act's definition of discrimination under Section 3 is broad. However, it prohibits discrimination in employment both during recruitment process and in the course of employment, that is vis-a-vis the terms of employment, opportunity for promotion, transfer, training, and other benefits, as well as dismissal. The provision also prohibits harassment by an employer or an employer's representative of employees and those applying for employment. In addition, the section creates a duty on all public organizations to ensure representation of Kenya's diversity and to employ no more than one-third of staff from the same ethnic community. Okay. Now, the HIV and AIDS Prevention and Control Act, this is discrimination based on health status. Section 31, subsection 1 of the Act prohibits denial of access to employment, transfer, denial of promotion, or termination of employment based on HIV status, though this is limited by Section 31, subsection 2, which states that the prohibition shall not apply where an employer can prove that the requirements of the employment in question are that a person be in a particular state of health or medical or clinical condition. And then another legislation is the Sexual Offences Act, or she knows or ought to reasonably know unwelcome, punishable by imprisonment of not less than 3 years and or a fine of not less than 100,000 shillings. This is particularly pertinent with respect to employers and managers as they are in a position of authority over the employees. Now, another legislation is the Employment Act. Section 5, subsection 3 of the Act prohibits discrimination on grounds of race, color, sex, language, religion, political or other opinion, nationality, ethnic or social origin, disability, pregnancy, mental status, or HIV status. The Act covers both direct and indirect discrimination and harassment, though no definitions are provided for these forms of conduct. Um, yeah, so the Act provides a number of exceptions to the protection against discrimination. That is Section 5, subsection 4 provides an occupational requirement exception which stipulates that it does not constitute discrimination to distinguish, exclude, or prefer any person on the basis of an inherent requirement of a job. Then we have policy framework, which policies also advocate for non-discrimination. Okay, so policy framework, we have the Kenya Vision 2030, provides a long-term development blueprint for Kenya. However, it provides only limited recognition of the importance of non-discrimination. Okay, so sections 5.6 and 5.7 are of particular relevance to promote non-discrimination. In respect to gender, youth, and vulnerable groups. Then we have National Policy on Gender and Development. It was published in 2000, the year 2000. It has a number of general objectives, including regarding non-discrimination, including to enhance measures that guarantee equity and fairness in access to employment opportunities in both formal and informal sectors, to and develop and improve vocational skills and training for disadvantaged groups like unemployed youth, disabled women, poor urban and rural women, street dwellers. Okay. And the public, we have another policy, public sector workplace policy on HIV and AIDS. It puts in place a national policy that defines an institutional framework and intensifies intervention measures for the prevention, management, control, and mitigation, of impacts of HIV/AIDS. Now, grounds for discrimination, we have race. The first ground is race. Racial discrimination is defined in international law as any distinction, exclusion, restriction of, or preference based on race, color, descent, or national or ethnic origin, which has the purpose or effect of nullifying or impairing the recognition, enjoyment, exercise of human rights and freedoms in either the political, economic, social, cultural, or any other area of public life and also private life. Now, in the context of employment, racial discrimination may be defined as treating an employee unfairly based on the color, ethnicity, or race. This can affect any aspect of employment, can be during hiring or firing, promotion or transfer, allocation of benefits, compensation, and the general work environment or working conditions. Section 5, subsection 3 of the Employment Act prohibits discrimination with regard to any aspect of employment, including hiring, firing, pay, job assignments, promotions, layoffs, training, fringe benefits, and any other terms and working conditions. A person who suffers racial discrimination uh, in the context of employment is entitled to seek redress from the courts under Articles 22 and 23 of the Constitution, which we say that any person who believes that their freedoms or rights have been infringed has the right to institute a court proceeding. Okay, now we have a case. Now, in the case of David Wanjua Mohoro versus All Pejeta Ranching Limited, one of the issues in dispute was wage inequality based on racial discrimination during his employment with the respondent. The claimant was subjected to unlawful discrimination based on his color. White managerial staff holding similar responsibilities to the claimant and other black managers were paid disproportionately higher salaries. The court found that indeed the claimant was discriminated against by the respondent on account of his race and paid an unequal pay for equal work or work of unequal value. He was awarded damages. This case is also, we mentioned this case where we were talking about indirect discrimination. Okay, now then in Charles Muthama versus Wananchi Group Limited, the claimant claimed to have been subjected to cruel, degrading, and inhumane treatment and was constantly abused and humiliated by one of the respondents' director, Richard Bell, who is a white Kenyan. The mistreatment was discriminatory and bordered on racism. Richard Bell threatened the complainant with a gun. When this incident was reported, rather than dealing with the issue, the respondent chose to end the claimant's contract of employment. The dispute in this case was mainly unfair dismissal. The court found that indeed Mr. Muthama was unfairly dismissed. In Dr. Samson versus Kenya Medical Research Institute. The petitioners alleged that while working for the program, which is run in partnership with the University of Oxford, UK, they were passed over for promotions and grants. When the doctors raised their concerns with the institution, their research was suspended. The doctors claimed that they were given changed, ambiguous, and inferior terms for return to the institution. Cambridge denied all the allegations lodged against it. The court sided with the petitioners and ordered the respondents to compensate each doctor with Kenyan shillings 5 million. Cambridge was found liable for unfair labor practices. Now, disability and health status. Section 2 of the Persons with Disabilities Act defines discrimination against persons with disabilities as to accord different treatment to different persons solely or mainly as a result of their disabilities, and includes using words, gestures, or caricatures that demean, scandalize, or embarrass a person with a disability. The Constitution of Kenya expressly prohibits discrimination, either directly or indirectly, against any person on the basis of their disability. We saw that in Article 27. The rights of persons with disability are clearly provided for under Article 54, and they include the right to be treated with dignity and respect, and to be addressed, okay, and referred to in a manner that is not demeaning. So that is Article 54. Excuse me. Okay. Now, Section 12 of the Persons with Disabilities Act provides that no person can deny a qualified person with a disability access to opportunities for suitable employment. Any qualified employee with a disability, like all other able-bodied employees, is subject to the terms and conditions of employment and the same compensation and benefits. Section 15 of the Act prohibits discrimination by both public and private employers in all areas of employment, including advertisement, recruitment, placement, uh, promotion, demotion, remuneration, benefits, training, advancement, apprenticeships, transfer or retrenchment. Okay. Now, so they must also accommodate people with disabilities using by providing facilities and modifications. Now, in addition, Section 13 requires that the what is this? The Yeah, so the Act also uh, says under Section 13 to reserve 5% of all casual, emergency, and contractual positions in employment in public and private sectors for people with disabilities. Yeah, so the Act provides for the right to recover damages in any court of competent jurisdiction with respect to discrimination in employment. Then we have a case in Northern Nomadic Disabled Persons Organization versus Governor County Government of Garissa. The petitioner's case The petitioner's case was that the first respondent's appointment of the Garissa County Executive Committee was not only unfair, but it was also unconstitutional. In dismissing the case, the judge stated, amongst other things, that the petitioner had not proved that any of its members had applied for the said post or any of its qualified members had not been considered. This therefore means that qualified persons with disability must apply for employment for them to be considered. Hence, in respect to human resource management in organizations, the same should, when recruiting, include persons with disabilities and ensure any such qualified persons are selected. This therefore means that qualified persons with disabilities should not be discriminated against. For example, if a blind person has all the requisite qualifications needed in a specific job specification, the same should be recruited and given the auxiliary aids required for him to work efficiently as any other person would have worked. There should be suitable provisions for persons with disabilities in their workplace environment to ensure their proper and smooth induction and socialization into the organization or company. The suitable conditions include making reasonable alterations or adjustments to the physical features of the organization. These may include widening doorways to allow a wheelchair to pass through, erection of ramps, and uh, disability friendly washrooms. Okay. Now, health status. The Constitution of Kenya under Article 27 expressly provides or prohibits discrimination either directly or indirectly against any person on the basis of their health status. So we have the public sector workplace policy on HIV and AIDS. This policy provides that all employees have the same rights and obligations. No employee or job applicant shall be discriminated against uh, in training, promotion, benefits based on their actual or perceived HIV status. Employees shall not refuse to work or interact with fellow colleagues on the grounds that the latter are infected or perceived to be infected. Such refusal shall constitute misconduct. Now we have a case in VMK versus Catholic University of Eastern Africa. The claimant was working for the respondent was discriminated against, denied fair and equal employment terms and conditions, and terminated from her employment due to her HIV status, amongst other reasons. The court opined that an employee or prospective employee may not be medically unfit merely by virtue of having been infected by HIV. It found that the respondent's actions constituted gross affront on the claimant's human dignity, contrary to Article 27 of the Constitution. So we have VMK versus Catholic University of Eastern Africa. From the foregoing, no employee should be discriminated against because of their health status, and in particular because of their HIV status, either at the recruitment, selection, induction stages, or at the socialization stages. The human resource management in each organization should put in place policies that ensure no employee treats another in an undignified or discriminatory way because of their health status. A good example is the Council of Legal Education's HIV and AIDS policy at Kenya School of Law, which provides for reasonable accommodation for the infected staff, which includes flexible working hours, time off for counseling and medical appointments, and extended sick leave. All employees should be accorded fair and equal terms and conditions of employment irrespective of their health status. In addition, the employers should not disclose their employees' health status to the other employees to avoid any form of discrimination in the organization. Then another ground on which discrimination takes place is marital status and pregnancy. Also, on marital status, discrimination on the basis of marital status typically involves discrimination based on assumed characteristics of people who are married, single, or divorced. That is, people who all share the same marital status. Mm. Marital status means whether a person is single, married, remarried, divorced, separated, or a surviving spouse. Unemployment cases includes protection against discrimination on the basis of identity, situation, actions, or beliefs of a spouse or former spouse. This occurs when the employer treats the employee less favorably because of their marital status compared to other employees who are not married. Marital status discrimination can affect both male and female employees. The discrimination can be indirect or direct. It could be direct if a single person who has the same experience and qualifications as the married person is promoted instead of the married person simply because he or she is single. Indirect discrimination, on the other hand, occurs where certain working practices, provisions, or criteria which apply to all employees place some employees at a particular advantage compared to other workers because of their marital status. The United Nations Convention of 1979 emphasizes the steps the government should take to prevent discrimination against women on the grounds of marriage or maternity and to ensure their effective right to work. These measures include protection from dismissal on the grounds of pregnancy, maternity leave, or marital status. That is 52. This is the CEDAW, the United Nations Convention on the Elimination of All Forms of Discrimination Against Women. Okay, pregnancy. Now, when it comes to pregnancy, it's defined as treating a woman, an applicant or employee unfavorably because they are pregnant or because of childbirth or a medical condition related to pregnancy or childbirth. So, mm, it occurs when a female employee loses her job or is treated differently by her employer or colleagues at work simply because she is pregnant. It also relates to maternity leave, where a pregnant female employee may be denied maternity leave or the employer may withhold her pay during the period of her maternity leave or fire her upon returning to work from maternity leave. According to an International Labour Organization report, maternity protection not just a personal issue in Kenya. Some women were forced to sign agreements promising that they will not become pregnant. Okay. Okay, so Section 29 of the Employment Act grants female employees the right to 3 months maternity leave. Okay. The Employment Act further specifies that no employer shall discriminate directly or indirectly against an employee or prospective employee or harass an employee on the grounds of pregnancy. Okay. Now, the state is obligated under International Labour Organization Convention 183 to adopt measures to protect the health of pregnant and breastfeeding women at work. It includes provisions concerning the entitlement to maternity leave and benefits. Member states are also explicitly required to ensure that maternity does not become a source of discrimination in employment, including access to employment and protection against dismissal. Yeah. The case of VMK also applies here versus Catholic University of Eastern Africa. And the facts of that case are the following. Um, in VMK versus Catholic University of Eastern Africa, is queer, yeah. It was discrimination at the workplace on the basis of gender, pregnancy, and HIV status. The claimant had been an employee of the respondent since the year 2000 when she joined as a casual employee in the position of a telephone operator and was earning Kenya shilling 7,000 as basic pay without benefits. There were two male employees in the same position employed on permanent and pensionable terms. In 2003, the claimant responded to an internal job advertisement, was shortlisted, interviewed, and was recommended for appointment. She was invited to discuss the new terms of her service, but her hopes were dashed when the respondent received the results of an HIV test done without her knowledge, consent, or authority. The respondent kept her on short and progressively shorter contracts with unequal terms due to her HIV status, refusing to have her refusing her paid maternity leave, followed by an immediate termination of employment upon return from the unpaid maternity leave. The court held that the respondent had discriminated against the claimant on the basis of gender, HIV status, and pregnancy. The respondent unlawfully withheld the claimant's salary whilst she was on maternity leave. The court was persuaded to find the respondent had violated the express provisions of Section 29 of the Employment Act, which provides that a female employee is entitled to 3 months paid maternity leave, and on expiry of the leave she has the right to return to the job which she held immediately prior to the maternity leave. The claimant was awarded exemplary damages. That was VMK. Then we have DMV versus Bank of Africa Kenya Limited. The claimant sought damages for Termination of employment on grounds of pregnancy. The claimant was initially employed by the respondent bank as a relations officer. She rose through the ranks, becoming a manager. When she was pregnant with her first child, she proceeded on maternity leave. Sometime in okay, she proceeded in maternity leave. The respondent learned that the claimant was expecting a second child. She was informed by the managing director that her services were no longer required. The court held that the termination of her service was based on her pregnancy and therefore discriminatory, unfair, unlawful, and in violation of the Employment Act, the Contract of Employment, and the Constitution of Kenya. Now, then we have discrimination based on sex or gender. Okay, gender. Discrimination on the grounds of gender is treating individuals differently in their employment, specifically because an individual is male or female. There are examples of instances of potentially unlawful gender discrimination that women, for instance, hiring, firing, promotion, where women apply for a job for which you have experience and excellent qualifications, but you are not hired because some of the company's long-time clients are more comfortable dealing with men. Benefits where a company's health insurance policy does not cover a woman's spouse because it is assumed that he will have his own benefits while the male co-workers have their wives covered by the policy. Protection against discrimination in the workplace is consequently a fundamental principle of labor law. Article 2 of the Constitution is enshrined as supreme law of the land and is binding on all persons. Article 27, everyone is on equality and freedom from discrimination. And Sub-Article 4 of the same article specifically prohibits discrimination on grounds of gender. Section 5 of the Employment Act renders sex discrimination unlawful in employment. We have a case, Jane Wairimu Macharia versus Mugo Waweru and Associates. The court held that the employer's conduct was discriminatory under Section 46 of the Employment Act. In addition, the court affirmed that every female employee had the right to a 3-month maternity leave, beside the annual leave enjoyed by all other employees. Failure of an employer to comply with this period amounts to a direct discrimination. Now, we have another case, Sidhu versus Aerospace Composite Technology Limited. The Court of Appeal in England stated that to find direct discrimination, the complainant must show that he has been treated less favorably than a person who does not possess his protected characteristics, and that the reason for the differential treatment is the complainant's protected characteristic. One act is enough, and as a general rule, the motive behind the action is irrelevant, and there is no defense once a direct discrimination has been proved. In British Airways plc versus Tama, the court held the British Airways liable for indirect discrimination against their female pilots by denying her the right to work 50% of her full-time contract after returning from maternity leave. The Employment Tribunal found for the claimant holding the British Airways has failed to provide sufficient objective justification for its provision. Uh, Another case is Sisley versus Britannia Systems, where a man applied for a job in a security control situation which only employed women. It was held that it was responsible in the circumstances given to refuse to employ a man for reasons of decency. A claim of indirect discrimination will be defeated if the employer can show that the provision or practice was justified. Lastly, there are various remedies that victims of gender discrimination can recover. They include an order declaring the complainant's rights. Financial compensation includes back pay, front pay, compensatory damages, punitive damages, a recommendation of action to be taken by the respondent or employer to reduce the adverse effects of the discrimination, and other remedies can include promotion, reinstatement, hiring. Okay. Another ground on which people are discriminated is religion or belief or conscience. Uh, uh, and have been given. Okay, so we have a case, Kokinakis versus Greece, that in applying Article 9 of the European Convention on Human Rights, which provides for freedom of thought, conscience, and belief, it will take into account both religious and non-religious beliefs. Conscience is commonly interpreted to include convictions that are not centered on the metaphysical. The need to protect individuals from discrimination on grounds of religion and belief. Uh, yeah, so they are diverse, and there are several examples of discrimination on this ground through history. For example, the Spanish Inquisition, for instance, saw thousands non-Catholics persecuted by the Spanish monarchy for holding different religious views. In 1672, England had a statute England had a statute that prevented Anglicans from holding military or public office as they were deemed to be enemies of the Catholic monarchy. Uh, Anglicans, let me just check. Now, Anglican is a Western Christian tradition that has developed from the practices of the Church of England following the English Reformation in the context of the Protestant Reformation. Okay, so this was a denomination in the Christian faith that came about, and these people were prevented from holding public office just based on their belief. Okay. Uh, Okay, so these are historical instances. Freedom from discrimination on grounds of religion is a universally recognized basic tenet of law in the whole world. There are several international conventions that seek to ensure that their signatories protect their citizens from discrimination. Okay, these provisions of international law form part of the laws of Kenya by dint or application of Article 2, subsection 6, and they include Article 2 of the Universal Declaration of Human Rights, Article 2 of the African Charter on Human and People's Rights, Article 2 of the Discrimination uh, Convention, Employment and Occupation Convention, formed in 1958. Okay, um, let's just take a look at this Article 2, Universal Declaration. So Article 2, everyone is entitled to all the rights and freedoms set forth in this declaration without distinction of any kind, such as religion. Okay. Article 2, I think they are the same. It's just the instruments are different. So the Constitution further guarantees the freedom from discrimination. Oh, excuse me. Within the Bill of Rights, Article 27 provides that the state shall not discriminate directly or indirectly on any ground, including religion. Article 20 that the Bill of Rights applies to all law and binds all state organs and all persons. Article 27 applies both vertically and horizontally, and that the requirement not to discriminate is imposed on both the state and private individuals. The three-judge High Court bench in Rose Wangui Mambo versus Limuru Country Club held that it cannot be safe in a progressive democratic society to arrive at a finding that allows private entities to hide behind the cloak of privacy to escape constitutional accountability. The court went on to hold that to provide to private entities to hold that private entities could not be allowed to violate fundamental freedoms in the Constitution, as this would be contrary to the intention of those who enacted it, and to do so would not be practical. Yeah, so let's see if we can find some facts in this case of this case. Okay, so Rose Wangui Mambo versus Limuru Country Club. Uh, so, okay. So the petitioners, among them Rose, was challenging a rule by the board of directors of the club. They contend that the amendment not only discriminates against female membership, but also it is a breach of their fundamental rights. So the petitioners, so the petitioners are female fully paid up members of the club. They have served in various senior positions at the club, with the first petitioner serving as vice chair and director of the club when she was until early 2013 when she was removed from office. The club which is a member of the Kenya Golf Union, is a company limited by guarantee. It was incorporated on 24th September 1945. Okay, let's just go to the facts of the case. Jeez. The controversy leading to the present petition can be traced back to a resolution of the Board of Directors which was passed. Uh, okay. Is a bylaw made by a majority of the respondents. Okay. It has the effect of excluding the lady golf members from participating in the golf general meeting election. So it was excluding the ladies from participating in the election. Uh, yeah. So the ladies could not participate but could only attend the meeting as guests. And the petitioners were complaining this bylaw was made only 3 days to the general meeting and only communicated to select members through email. This denied them an opportunity to raise objections to the decision. Uh, the whole business was whether the court can interfere with the bylaws of a private association or organization in the private sector. So let's see what the Nini court held. So the court held that that resolution. Wait, just a minute. That was the petitioner's case. Oh, this is so long. Oh, submission. Okay, determinations. So the court answered the question of jurisdiction, whether this court has jurisdiction, discrimination and equality, whether the impugn bylaw is discriminatory or otherwise offends the Constitution. Okay, so let's see. Mm-hmm. Okay. Mm, As to jurisdiction, the court said uh, that the golf clubs are private. That was the argument, that golf clubs are private entities governed by internal rules, and the court should not intervene. That there exist other alternative mechanisms. That was the argument of the respondent. So in determination, the court used the case of Samuel Kamau Macharia versus Kenya Commercial Bank. A court's jurisdiction flows from either the constitution or legislation or both. Thus, a court of law can only exercise jurisdiction as conferred by the constitution or other written law. It cannot arrogate to itself jurisdiction exceeding that which is conferred upon it by law. We agree with counsel for the first and second in his submission that the issue as to whether a court of law has jurisdiction to entertain a matter before it is not one of mere procedural technicality. It goes to the very heart of the matter, for without jurisdiction, the court cannot entertain any proceedings. This court dealt with the question of jurisdiction extensively in the matter of the Interim Independent Electoral Commission, where the Constitution exhaustively provides for jurisdiction of a court of law. Okay, it cannot expand its jurisdiction, nor can Parliament confer jurisdiction upon a court of law beyond the scope defined by the Constitution, where the Constitution confers power upon Parliament to set the jurisdiction of a court of law. The legislature will be within its authority to prescribe the jurisdiction. Article 165 grants jurisdiction to this court in the following terms. Subject to Clause 5, the High Court shall have unlimited original jurisdiction. So this is Article 165. The Constitution gave the High Court unlimited original jurisdiction in criminal and civil matters, jurisdiction to determine the question whether a right or fundamental freedom in the Bill of Rights has been denied, violated, infringed, or intervened, jurisdiction to hear an appeal from a decision of a tribunal appointed under this Constitution, to consider the removal of a person from office other than a tribunal appointed under Article 144, jurisdiction to hear any question respecting the interpretation of this Constitution, including the determination of the question of whether any law is consistent with or is in contravention of this Constitution, the question whether anything said to be done under the authority of this Constitution or of any law is inconsistent or contravenes this Constitution, and in respect of any matter relating to constitutional powers of state organs, in respect of county governments, and any matter relating to the constitutional relationship between the levels of government, a question relating to conflict of laws, and finally a question any other jurisdiction, original or appellate, conferred on it by legislation. So I think this would apply that the court has jurisdiction to hear this matter based on the Bill of Rights, to determine question whether a right of fundamental freedom has been infringed. Okay. So, and Article 23 also grants the court authority to enforce the Bill of Rights. Yeah. So from the above constitutional provisions, the court has jurisdiction. Moving on. Okay, so moving on to the issue of, okay, yeah, so in this case it was held that the court has jurisdiction. Also, I want the final verdict. I want the verdict. Come on, it's too long. What did the code say? Come on, let's go. Let's go. Let's go. Let us go. Okay. So it held that the constitutional protections apply both vertically and horizontally. Yeah. So the court held that yes, that bylaw excluding ladies from participating in that meeting was discriminatory and also in violation of the right to freedom of expression under Article 33 and also Article 27. Mm, yeah. So the court held yes, it was discriminatory, and the reliefs were awarded in light of our findings. Okay. We said the reliefs can include a declaration of rights, injunctions, conservatory orders, or an order of judicial review. Can also, where it's about the unfair dismissal, become compensation, service pay, yeah, compensation, service pay, and others like leave pay and what else? Reinstatement. So the court ordered a declaration that the resolution is null and void. An order of mandamus is hereby issued to the first respondent to reinstate the petitioners as members of the club, and the Kenya Ladies Golf is directed to ensure that orders are implemented. Okay, so that was the case of Rose versus the Lemuru Country Club. Okay, so that I think, that has concluded our case on discrimination based on, yeah. So thank you so much. I'll see you next time, and all the best in your exams.